A judge has directed Los Angeles prosecutors to justify why Erik and Lyle Menendez's murder convictions should not be re-evaluated given new evidence that bolsters their claims of sexual abuse by their father, as reported by RadarOnline.com. This development reignites discussions surrounding the infamous case. Erik and Lyle were convicted in 1989 for the murder of their father, Jose Menendez, a record executive, and their mother, Kitty, in their Beverly Hills home. The defense maintains that the brothers acted out of self-defense after years of abuse, while prosecutors contend that their motivations were driven by greed for a multi-million-dollar inheritance. Recently discovered evidence includes a letter from Erik to his cousin Andy detailing the alleged abuse, and a statement from Roy Rossello, a member of the boy band Menudo, who claims he was raped by Jose Menendez in the 1980s. In his memoir Crazy Lucky, celebrity lawyer John Mason, a friend of the Menendez family, addressed the speculation, noting that investigators failed to test the brothers for gun residue after the shooting. Despite the emerging evidence, Mason expresses skepticism about their innocence, stating, "Of course, I wasn't privy to every single moment at the Menendez house. It wasn't long before I began to see them as two young men who wanted to inherit their father's multi-million-dollar estate. They were impatient. They didn't want to wait for him to die." The Los Angeles County District Attorney's Office has 30 days to argue against the brothers' potential habeas corpus relief. Recently, a judge reduced their sentences to 50 years to life, making them eligible for parole as early as August. "I'm not suggesting they should be released," said Los Angeles Superior Court Judge Michael Giesecke. Cliff Gardner, the brothers' attorney, presented the letter and argued that it reflects their belief they needed to protect themselves, suggesting a culpability for manslaughter rather than murder. In contrast, District Attorney Nathan Hochman dismissed this argument as inadequate, asserting that prior communication of the alleged abuse should have emerged during their testimonies.